There's a financial penalty of up to 4 times the deposit. Deposit registration has been out for absolutely years. I think it's 6th of April 2007. But it is one of the pieces of legislation that if you get wrong, you cannot correct, because you can't go back in time and fix the problem if you do not meet the requirements under the legislation. So even though it's been around since 2007, agents, landlords still have questions surrounding how to comply with it completely and be factually correct. So we do all now know that there's a cap, I hope, in England of 5 weeks deposit. The calculation that you use needs to be the specific calculation, which is the rent times 12 divided by 52 times 5. You have to use that calculation, because if you don't use that calculation, you will not come to the right amount. It is important that you make sure that you are taking the right amount of deposit. And one of the questions today was surrounding deposits that were already in place for tenancies before the cap. Do you have to reduce them? The answer is no. If the tenancy doesn't renew, and the periodic contract became periodic before the tenant fee ban came into force. So if they're going on to contractual rolling tenancies and you're not renewing the tenancy, you do not have to reduce the deposit. Now, I know most agents just went in and reduced them all because it was easier. But there's an element of argument that I give to you here that we have to work in the best interest of our client. Would you agree? That's our legal duty. If you're giving money back to a tenant that shouldn't have been given back to the tenant, and therefore giving the landlord less protection than he legally could have had, who do you think is going to be responsible for that difference if there was ever a claim? It would be us. And most landlords will take small complaints to the TPO or the property redress scheme. In that scenario, the TPO would most likely award the landlord the difference if there was no legal need for you to reduce that deposit. If you've just done it because it saves you time and it was easier to do that, then you are going to have to stump up the loss that he may have occurred because of your actions. So let's get to the basics, right? You must register the deposit within 30 days of receipt. That word is really important. It's not from the start date of the tenancy. It's from the day that you receive that money into your bank. And the clock starts ticking on that day. So if the tenancy doesn't start within the next 30 days, you're going to have to register the deposit before the tenancy commences. Does that make sense? Because you are holding the deposit. You also have to issue prescribed information within 30 days of receipt. So the key word here is 30 days of receipt. And then this is where it gets complex. Each scheme has a different variety of things that you need to give. So the DPS, I think now is a certificate. It's the terms. It's the prescribed information. TDS is a certificate, a leaflet, and the prescribed information. So you can see each scheme has different documentation that need to be issued to the tenant. And you need to be able to prove that you have issued those documents within the time. If you don't, there's a financial penalty of up to 4 times the deposit, so 3 times the deposit plus the deposit. So that's the financial implication. But you may also face challenges if ever you need to seek possession of the property under a Section 21 notice, and also maybe a Section 8. The deposit doesn't need to be registered in order to serve Section 8. But what can happen is the tenant can make a counterclaim against you if you have failed to comply with the deposit laws when you're going to court on a Section 8. And this happened to me down in Oxford. A landlord had got a property and she'd been renting it out for 10 years. And throughout these 10 years, she'd used 2 other agents before she brought it to us. When it went from agent 1 to agent 2, there was a week in between that transfer where the deposit wasn't registered. We went to court and we got a possession order. Tenant then went to citizens' advice and got a court date the next day. How long do we wait, guys, to get a court date? So long. They got one the next day. And it was an appeal against the possession order. And cut a long story short, the tenant won and was awarded 4 times the amount of the deposit. What did that do to the rent arrears? Reduce them. Can we now serve Section 8 and rely on Ground 8 for mandatory possession? No. So the case got thrown out of court and the tenant had to stay. Within the court case, there was an agreement that this was the one and only time the tenant could pursue the landlord for this. You've had your compensation, you can't claim again. So what we then had to do was serve Section 21. and we were able to serve Section 21 because the issue with the deposit had been dealt with through the court of law and she couldn't rely on that again. So it was another 4 months before the landlord got her property back, following being given a possession order. So although it doesn't directly have any effect on the Section 8 or the serving of it, counterclaims can literally rip your case out of court if there's a successful counterclaim made. And as I said there, penalties are 3 times the deposit amount plus the deposit. It's just not worth it. Make sure your team knows. So some of us have big teams. If they are responsible for this, make sure that, you as senior operators, either your managers should be checking that it's done properly, or you should be making sure that you're doing an audit to ensure. So for example, we have 3 checkpoints in our business as to when this is checked. When the tenant first moves in, and then my tenancy managers run a weekly report every single week to check all of the tenancies that have moved in have had the deposit documentation issued and signed and so forth within the 30 days.